Welcome to Property Power Talks, the exclusive podcast for NB Property Law. I'm your host, Kayleigh Swift, and each episode will dive into cutting-edge insights on property law, probate, estate planning strategies, and seamless estate administration. Whether you're a property investor, homeowner, industry professional, planning your estate, or wanting to understand how estate administrations work, then our expert discussions will empower you with the knowledge you need to navigate the complexities of property and estate planning law with confidence. Let's unlock the power of property and estate planning law together. Thank you for joining me. We ourselves as entrepreneurs understand the difficulties that come with starting a business or a new enterprise, which is why we thought today would be beneficial to run through the importance of actually having terms and conditions. Obviously, commercial law, property law, we do generally work quite hand in hand as we do similar matters. So terms and conditions are certainly something I'm very familiar with, I've drafted for many clients over the years. So today we'll take you through what elements make up terms and conditions, what are considered unfair contract terms, and what are the penalties that will apply if unfair contract terms are found to be present in documents that you're acting in or one of the parties for. So looking at the next steps for business owners when they're looking to step away from the business, whether it be looking at employee shareholder agreements and those things. Obviously, as discussed, though, we're going to focus on just one element of those services today, being terms and conditions. So it is very important that every business that's providing a service or providing goods has a terms and conditions agreement in place with their customers. Obviously, for retail, people selling, e-commerce and things like that, those terms and conditions might just be a simple tick of a box when their clients are purchasing products online or in a store. For those that are providing professional services like ourselves as lawyers, we stipulate those things in, for us, we call it a client agreement that will clearly outline what the services are we're providing. So with terms and conditions, they are basically forming a backbone of contractual agreements between the business and their clients, outlining crucial details to protect both parties' interests. So a well-crafted set of terms and conditions should comprehensively cover the things that are listed here. So these are just a few of them, obviously not an exhaustive list, but I think that the four most pertinent ones, which are the description of the products or services, what are the delivery terms that the business is providing, what are the payment terms on offer, and what happens if those payments are not made on time. Also, the other things to think about are things such as retention of title, what is the risk and insurance involved in the service or products that are being provided, what are the order changes and cancellations that will be allowed for by the business, are there personal guarantees that are being requested? Maybe this is not a simple agreement, it might be quite an extensive contract that's being entered into. You might be a builder or trade of some sort, entering into big matters where they're forking out a lot of money for materials and things like that. Also, security clauses. So we'll go through them in greater detail now. So in terms of the description of the product or services, so basically this is providing a detailed description of the products or services that are being provided, including specifications, features, and any limitations or exclusions. So the description should help set a clear expectation for both parties regarding what will actually be delivered. So, this is one of the important things, like what is the actual product or service that's been given? And both parties need to be aware of that so that they know as the customer what they're actually paying for that, and as the service provider or product provider, what they've actually got to deliver for that amount of money that the customer's paying. Now, the next important term is the delivery term. So this needs to specify when and where the product or services will be delivered or provided. So it should include details on any conditions for delivery, such as scheduling requirements or client responsibilities. So, generally speaking, for products, obviously that's quite simple. You're basically getting payment maybe at the point of sale, if it's online or in person, and If it's in person, obviously the goods are generally exchanged then and there. Sometimes they might need to go on back order, or it's a lay-by situation. Whatever it should be, that needs to be stipulated and how that will work. For professional services, sometimes it's a little bit more difficult. You might be waiting on instructions and things like that to come from the actual client before things can be delivered, but it still needs to be encapsulated in the client agreement. So, what is it that we're waiting for? When must that be provided by the client? And once that's provided, when will the service be delivered to that client? Now, payment terms. So this should outline the pricing structure, including the total amount the client needs to pay. It should include specifics on when payments are due, acceptable payment methods, and where payments should be remitted. So it might all sound quite straightforward, but it's still important that it's actually stipulated. For example, with payment terms, if a client is paying via PayPal, or there's so many different methods out there now, EFT, there's delayed payments where they're paying installments over a period of months through a third party potentially. How does that all work? Is the client responsible for paying those third party surcharges? If they're paying by Visa or MasterCard, is there a transaction fee? Is there a minimum limit that they need to reach before they don't pay shipping if it's a products business? All that needs to be made sure that it's clearly outlined in those terms and conditions so that the client knows what they're signing up for and the pricing structure of that. Now, feel free as well, so I didn't mention at the start, if you do have any questions, write them down, put them in the chat box, and I will be happy to answer any of those at the end. Now, the next important term is the consequences for late payment. It's fine to, clearly outline what those payment terms are, but basically we need to make sure they're enforceable and what happens if the customer does breach those payment terms and doesn't pay on time. So it must clearly state in this term what the consequences are, and this could be things such as late fees, interest charges, or additional costs such as debt recovery fees. You need to ensure that these fees are reasonable and compliant with local regulations. So we can't just go saying you didn't pay the $100, now all of a sudden we're going to double it to $200 because you were late. It does need to be reasonable. We're going to get into the unfair contract terms in a moment, but it needs to be, reasonable and in line with what legislation says. So in terms of terms and conditions, they're generally regulated by what's called the Australian Consumer Law. So it's fine to charge interest charges, which may be, what the current, bank's interest charges are. A late fee would just be generally a small amount. So example, they didn't pay, the $100 when due. They might simply just pay, $5 extra as a late fee. Additional costs such as debt recovery fees. Now that line, not just debt recovery fees, but potentially solicitors as well. If a client is breaching the terms and conditions, you want to be able to put those charges onto them. You don't want to be responsible for the debt recovery fees, having to engage a lawyer to basically send some letter of demand and actually formally litigate the matter to get the money back, which, when we're talking about big sums of money that potentially is overdue, like I mentioned trade example before, if they've already forked out a lot of money for materials, we need to make sure that that's all covered off on. The other one that I spoke about previously was retention of title. Now, including a clause about retention of title should clearly state that the ownership of products or services remains with the business until full payment has been received. So like I said, in terms of those materials, that title to those materials, for example, if it was an aircon installer, some of those commercial aircon equipment that they're putting in buildings, they add up to quite a lot of money. So the title of that property needs to remain with the aircon installer until final payment has been made. Now, we would recommend generally putting what's called a personal property security charge over those goods, meaning that definitely the title then remains with the installer until final payment is made. That's all something obviously we can assist with if you're unsure of what I'm talking about and when I'm talking about a personal property and securities charge. This retention of title clause is essentially going to protect the business in the case of non-payment, or if for whatever reason the client went insolvent. So, as the aircon installer in the building, you know, maybe the client is actually the builder, but if the builder went under, which, you know, unfortunately we've seen in recent times with a lot of the big building companies, we need to make sure that our client can then still go in and get their materials out, get their tools that have left on site, etc., even though liquidation may be going on with that building client. Risk and insurance I mentioned before as well. So we want to be able to specify the risk in the products or services and how that transfers to the client. So especially for goods in transit or storage. So you need to outline if there is insurance coverage included or required during the transportation or storage. So for example, going back to, you know, e-commerce again, when you're selling might be quite expensive products online, and at the point the client obviously pays at the point of ordering the goods, at which point is then probably delivered. Who then is responsible though for the courier, or, you know, maybe it's Australia Post, who takes responsibility for that good before it actually arrives to the client? So, you know, if the good ends up, you know, at the wrong address or something like that, and that's of no fault of the customer, how does the insurance work with your business to cover replacement of that item? Or is it you've, you know, reviewed obviously the terms and conditions with the courier company, and they're going to take responsibility to reimburse you for that, but essentially you still need to provide the product again. So it needs to all be stipulated in those terms and conditions as well. Also, the other one I mentioned is order changes and cancellations. So you really need to define the period of notice required for changes to orders or cancellations. So state any applicable cancellation policies, including whether cancellation fees will apply. So obviously this is in addition to, you know, any late fees or things. This is talking about actually cancelling the order altogether. And that will be different for each of your businesses, you know, what your requirements are. If you're ordering a product and, like I said, they've paid and you've already dispatched that order, it's a bit hard for that order to be cancelled and refunded unless the client's, you know, going to return the goods at their cost, and you actually obviously receive them intact. For services, obviously that may be a little bit easy. You may be able to refund and cancel the order if the service hasn't actually begun to take place. But it all depends on what your business is, but it just needs to be stipulated, you know, as to what your requirements are in terms of changing the order and varying it. You know, if you are, you know, professional services, we will send out an original client agreement. We may then send out a variation to that client agreement if, you know, we get halfway through the matter and all of a sudden a client wants to deviate and take a different route, or for whatever reason they need to add on to the services. You know, we've done the business purchase and now all of a sudden they need to do the commercial lease for the tenant that's in the property or the tenant they've just found. Another important one to think about is personal guarantees. So if this is applicable, you need to be requesting the personal guarantees from the director or the principal of the client company to ensure payment security. So it should outline the circumstances under which these guarantees will be invoked. So, you know, there's obviously no point in having a personal guarantee if the customer or the end user, the product, is an actual individual, because personal guarantees are really only needed when it's actually a company that's the customer. You know, for all we know, it could be a $2 company, and therefore we want to rest assured that we're going to actually have proper instructions from the company, and we're not just going to be forking out all this money for goods or services, and you know, they just run away or we never hear from them again. We just need to make sure though, like I said, that we're getting the guarantee signed off by the correct person, which could involve you having to do what's called an asset company search to check who the current directors and or secretary is at the time. Now, in terms of directors and even signing off on terms and conditions, etc., under Corporations Act, we only need like 2 to sign, and therefore, you know, you might only have a couple of the directors as personal guarantees. Obviously, in an ideal scenario, you'd have all of them, but if the company is made up of, say, 8 directors, they might not all agree to providing such personal guarantee. The last clause I mentioned was the security clause. So including a security clause will allow the business to register security interests, such as charging clauses over real property like real estate, or personal property security register, again, which I mentioned before, over personal property of the client. So these clauses can help secure payment and mitigate the risks associated with the non-payment or insolvency. So I spoke a bit before about the personal property security register, known as the PPSR, but the other option is a charging clause over real property. Now that's often used, like, you know, for example, by banks when they put a mortgage over your property. That's a charge over real property, over real estate. You know, there's things like known as like caveats, you know, where basically that's associated with a debt. So if a client is not paying, so, you know, maybe you're building their house, they haven't actually paid the final payment or maybe the last 2 payments or whatever, your clause may allow that, you know, you lodge a caveat over that property, which means that the seller, you know, any buyer that's doing their due diligence and engaged a property solicitor wouldn't be selling that property until that caveat is discharged, and you wouldn't be discharging that caveat until you're essentially paid out what was owing to you. All right, so moving on then to the wording of the terms and conditions. So obviously it's great to have all these terms and conditions, but they're really quite pointless unless they're actually worded correctly. So to ensure your business terms and conditions are robust and compliant with the Australian laws, you need to consider the best practice, and that includes using clear language, language that's also understandable. It's fine to, you know, use all this legal jargon or, you know, things that you might think are pertinent to your industry that you understand, but it needs to be really clear for both parties. The language needs to be understandable, and the language needs to avoid any ambiguity. It's no point having any terms and conditions included if it's just, you know, real wishy-washy and doesn't really give a definite, you know, yes or no answer. So as I mentioned before, the next part of this webinar will be about the actual unfair contract terms. So again, great to have terms and conditions in place, but if they're considered unfair, they're going to be considered void. And in all our terms and conditions, we would always have a clause in there that says, you know, should one section of the terms and conditions be considered void, you know, the remainder of the terms and conditions would apply. You want to make sure that that kind of standard clause is in all your contracts, whether it be terms and conditions or whatever, because, you know, laws do get updated. So if you haven't updated your terms and conditions and all of a sudden new Australian consumer law comes out to say something's, you know, a breach of a consumer law, yet you've got it in your terms and conditions, you know, you want to just be able to basically strike that clause out, but have the remainder of those terms and conditions apply. So in late 2022, there were amendments made to the Australian consumer laws, and a bill was passed by both, you know, levels of government to have new legislation basically in effect from 9th of November 2023, which significantly bolstered the unfair contract terms regime in Australia. Now, for business owners and managers who are unfamiliar with what that regime, obviously, you know, we're going to go through that a bit now and what that means for you. So unfair contract terms, they've essentially been in place since 2010, but like I said, they've, you know, been revisited in late 2023, and basically, you know, since 2016 have looked at what, you know, small business contracts, you know, essentially cover. So unfair contract terms are those which, if relied on, would cause a significant imbalance to the parties' rights and obligations arising under the contract. They are not necessarily there to protect the legitimate interests of a party. Unfair contract terms could also be those that cause detriment to the other party as well. So, you know, knowing that, these are obviously a few examples of what would be considered unfair contract terms. So, for example, you know, you need to avoid and make sure, hopefully none of your terms and conditions have them in there currently. If so, you need to get them renewed, you know, immediately, to have any automatic renewers and contract rollovers. That's an unfair contract term. It's going to be void. There needs to be no disproportionate or unilateral termination rights. Another example unfair contract term is if there were provisions to seek to unreasonably limit a party's liability. And lastly, any excessive termination fees. So like I mentioned the example before, we're charging $100, we can't then charge $100 just because they've terminated the agreement. Like that's not reasonable. So knowing that, what happens if you do not maybe amend your terms and conditions that include these unfair contract terms, or if you were, just to draft some new terms and conditions today that included these unfair contract terms. So as I said, from November 2023, when this legislation got amended, it is considered an offence to enter into standard form consumer or small business contract which contain unfair contract terms. So there are maximum penalties though for doing so. And that's as listed here. So we've got, there's a couple of different options. So it's either a 50, this is the upwards limit, obviously. This is the worst case scenario, is the business would be charged $50 million. Otherwise, they'd be charged 3 times the value derived from that unfair contract term. So for example, they're charging a $200 cancellation fee. They'd be charged 3 times of that, being $600. Or the other option is the court may award that the business has to pay 30% of the adjusted turnover of the offending business during the period of breach, or the previous 12 months, whichever is the longer period. So the charges also extend the meaning of what a small business contract to cover a much larger array of businesses. So the new definition as of the end of 2023 defines a small business contract to include contracts for the supply of goods, services, or interests in land where at least one party employs fewer than 100 persons or party's turnover is less than $10 million. So basically, if your business employs less than 100 people and has a turnover of $10 million, then these unfair contract terms could potentially apply to your business. So in practical terms, many, if not most businesses will regularly enter into either consumer contracts or small business contracts as defined under this new law. This means that standard form terms and conditions need to be carefully scrutinised to avoid inclusions of these unfair contract terms, which may be void, but also now attract actual prosecution and penalties as we've just gone through in this slide. So you just need to be very aware of that. So knowing all that, how do we go ahead then and actually draft effective terms and conditions? So you want to ensure that your business terms and conditions are robust and compliant with the Australian laws. And to do so, you need to consider what are the following best practices. So you need to actually consult with your legal experts. I said at the start, this is something we do on a day-to-day basis. So I would recommend, if you haven't had terms and conditions drafted correctly in the first instance, that you do reach out to us and get us to review your existing terms and conditions. Maybe you need them updated since the new laws come in at the end of 2023. Hopefully everyone does have terms and conditions, but if you don't, maybe you're a startup or looking to start up a new business, that you come to us and get those drafted so that we can make sure that they are free from any unfair contract terms to avoid those breaches. Now, the other thing to be wary of is making sure that they're clear and simple. So you need to always use clear and understandable language to articulate the terms and conditions and avoid any overly technical jargon that may confuse customers. All right, so it's fine to have, lots of terms and conditions included in your T&Cs, but if you just literally go on this long rant about things that are just, they really make no sense, it's pointless having them in there. Lastly, regular updates. So you need to periodically review and update your terms and conditions to reflect changes in business operations, industry regulations, or even legal requirements. As I mentioned, these laws, they've been in place not quite 12 months, but we really want to be reviewing our terms and conditions every 12 months. Otherwise, if we know there's new laws that have come into place, making sure that we're updating them as those reviews come in. We issue a newsletter on a regular basis, including articles about new changes to laws and things like that. So we don't expect, clients to be aware of all the changing laws, but that's what we do for our clients. We educate them like we're doing so in this webinar, and also, with our social media posts, our newsletters, so that clients can be up to date with, the changes in the laws, so we can hopefully help them to avoid any of those penalties we mentioned before. I'll probably as well, before I jump to Q&A, I'll just touch on a bit more in depth regarding the actual personal guarantees. So basically, I mentioned before having the personal guarantees, but I suppose going into a bit more, why why it may be considered a good idea to have personal guarantees. So with personal guarantees, it depends on, like I said, the situation with, who you're entering into contract with. You're only wanting to have them, when there's an actual company that is the client. So directors and guarantees must not take guarantees lightly, and always understand what they're signing up to when they're agreeing to provide a personal guarantee. So while you may expecting your clients to enter into personal guarantees, you as a business owner as well from time to time may be asked to sign up to these things. And it is important to be aware that this is going to impact on your personal assets. So if for whatever reason you or a client can't pay the money, it then comes back to you personally. So what personal assets do you have? Homes and cars and things like that. They're all basically on the table to sell off if needed to repay the money that's owed. So it's always important to read and fully understand the guarantees being provided, and where there's actually a charging clause involved, negotiate strict drafting on its application if possible. So directors should always maintain records of all guarantees signed in the course of their business, if any, to ensure that the date information about personal exposure is understood. And for suppliers and creditors, they should always be reviewing those terms and consider a well-drafted charging clause, when we're doing our terms and conditions like this. That's what we're doing now. The other clause that I didn't touch on, which come into light a lot during COVID, was what's called a force majeure clause. Now, force majeure clauses, as I said, they gained significantly attention, in the global disruption, which COVID-19 pandemic was considered one of these, and those clauses were crucial for parties seeking protection for events which were basically beyond their control of impact during their contractual performance. So in Australia and in many other jurisdictions, the interpretation and enforcement of force majeure clauses can significantly influence contractual outcomes. So basically, what actually is a force majeure clause? It's not, a term that probably many of you are aware of unless you've, come across them in your dealings, but basically it's a French term translating to superior force, and it typically refers to unforeseen circumstances or events that prevent a party from fulfilling its contractual obligations. So these events are typically beyond the control of the contracting party and are often characterized by unpredictability and inevitability. So, for example, a force majeure clause may be invoked where a supplier fails to deliver building materials to a work site by a deadline because of widespread and unseasonal flooding. So the effect of a force majeure clause in this situation would be to excuse that builder from the failure to the extent it caused by the unseasonal flooding event. So the actual force majeure concept then does not really exist in the Australian legal system except where it's been contractually agreed. So in other words, to be excused from a failure to perform a contractual obligation on the basis of a force majeure event, the contract must include specific provisions to this effect. So if we are including force majeure clauses in our terms and conditions, it needs to specifically state, what is a force majeure and when would it be affected and how. So the effect of the force majeure clause will depend on the actual interpretation of the contract. So basically, it is important to understand what force majeure is simply as a concept, and that any given contract that you're entering into or your terms and conditions can use a different expression to, the next contract that you're signing. And, for clients, these terms and conditions will potentially include a different force majeure to the next ones they sign. In COVID, like if you're wondering, were force majeure clause, effective in COVID then, could all these clients just go terminating their build contracts or their services agreement, which was on a retainer with, us as lawyers or whatever. So that global pandemic underscored the importance of a well-drafted force majeure clause. And in Australia, as elsewhere would have seen, parties did face unprecedented challenge at that time with contractual obligations due to, the government-imposed lockdowns, travel restrictions, disruptions to, supply chains and things like that. So contracts that did at that stage explicitly include pandemics, epidemics, or government actions related to public health as force majeure events were better positioned to navigate the uncertainties of the pandemic. So in contrast, contracts with vague or very generic force majeure provisions faced increased scrutiny as to whether they would be seen as valid. in terms of force majeure, like versus like a frustration of a contract. So frustration basically is a similar legal concept recognised in Australia common law, and frustration will occur where an unforeseen event radically changes the nature of contractual obligations, so making it impossible, maybe illegal, or even just commercially absurd. So in these cases, the contract may be considered frustrated, relieving the parties from the further performance. So, your terms and conditions may be at that stage just considered frustrated. So it is significantly different, a frustrated discharge, because the parties are the further obligations on the contract, whereas the force majeure could just be a temporary relief. So for example, your terms and conditions may state, like the example before with the builder, materials need to be provided by 1 week. The seasonal flooding happened, they therefore were allowed 4 weeks, because that's how long the flooding went on, whatever it might be. Whereas the frustration is a more narrow doctrine, and that may not cover all situations where the force majeure may apply. So the inclusion of a well-drafted force majeure clause in a contract does provide parties with a more comprehensive and tailored framework for addressing unforeseen events. So I suppose some hints and tips, when drafting your terms and conditions and looking to maybe put in a force majeure clause, the things to be basically aware of is that you need to clearly define the events that will trigger the clause, such as natural disasters, acts of terrorism or pandemics, and generic language such as acts of God may be too broad and subject to interpretation, because we don't know what is an act of God. Like, what I think is an act of God may be different to what the next user thinks is an act of God, and therefore it is just too ambiguous, which, as I mentioned before, we want to avoid at all costs with our terms and conditions. So while specific events should be listed, it's also advisable to include a non-exhaustive list to cover unforeseen circumstances. So this will allow for flexibility, ensuring that events not explicitly mentioned but meeting the defined criteria can still be considered force majeure. You must also ensure that force majeure events directly cause the inability to perform contractual obligations, and there should be a clear nexus between the event and the party's non-performance. So the connection is vital to prevent parties from using force majeure as a pretext for avoiding contractual duties and unrelated to the triggering event. The other thing to think about is establishing the clear notice period required for invoking a force majeure clause. So obviously timely communication is going to be essential to all parties when assessing the situation and being able to plan for it accordingly. So failure to provide prompt notice may impact the invoking party's ability to claim relief. Go back again to the example we give with the builder and the unseasonal flooding. If flooding occurred today, flooding's finished in two months' time, but yet he's asking for an extension at that point, it's too late. Like, the event's passed, and therefore it's not going to be able to be invoked as a force majeure reason for the delay. The other thing to think about is specifying the obligations of the parties to minimise the impact of the force majeure event. So this could include implementing alternative measures, so seeking reasonable substitutes. Again, it could be materials. We can't get that particular pine wood, but we can get this hardwood timber instead. That's what we're going to have to do in this situation. Your terms and conditions should allow for those types of things, so without having to invoke a variation clause. Otherwise, making efforts to resume performance as soon as possible. The flooding is finished on 2 weeks later, we're therefore going to have the materials due in another 3 weeks. Courts can often look favourably on parties that actively work to minimise the effects of the force majeure event. So you want to be seen as one of those people. We also want to make sure that you clearly outline the duration for which the force majeure clause will be in effect and the rights of determination or suspension during this period. So providing a mechanism for periodic reviews ensures that the parties can reassess the situation as it evolves over time. And then lastly, the thing to consider with force majeure events is that what is the potential impact of government actions on contractual performance? So expressly include government actions, changes in laws, regulations as triggering events. So this is particularly relevant when we look at situations like public health emergency, where the government interventions can be significant. So example of this, obviously COVID-19 with the lockdowns that they invoked. So overall, I suppose force majeure clauses can play a pivotal role in allocating risk in contractual relationships. And if you are getting terms and conditions signed off and having a force majeure clause included in them, you should consider whether they're drafted clause adequately and make sure that they remain ready and able to assist, with these types of matters as they arise. Otherwise, I think they're the main things, from a legal perspective, we would say are needed to be included in your terms and conditions, and obviously how you can make sure that they're effectively drafted to be compliant with the new laws that come into place at the end of 2023, making sure that we don't have any unfair contract terms. So in conclusion, though, I would just say when drafting business terms and conditions, they may seem like a procedural task, but it is significant to have within your business. It can't be overstated. So by adhering to the Australian legal standards, particularly under the Australian consumer law, businesses can build trust with their clients, they can mitigate risk, foster long-term success. So, consulting with your legal professionals like us at MB Commercial Law, it's just going to ensure that your terms and conditions are not legally compliant, but also that they're strategically advantageous for your business objections. We do understand the complexities of running a business, whether it be a big or small. We're here to obviously support you at every stage, give you clarity to help you with your entrepreneurial journey. Like I said, we'll post things from time to time to keep you abreast of all the new laws as they come to hand. But yeah, hopefully we've given you a bit of oversight about how terms and conditions operate and what are considered unfair contract terms. Thank you for listening and look forward to seeing you in person or having a chat with you. Thank you, everyone. Thank you for tuning in to another episode of Property Power Talks. We hope you found today's insights valuable and engaging. If you enjoyed the show, don't forget to subscribe and leave us a review. For more information or to connect with our expert team at MB Property Law, then please visit our website at noborderslawgroup.com.au. We look forward to having you join us next time for more expert advice and actionable strategies to master the world of property law. Until then, stay informed and stay empowered.